Disclaimer. All audio recordings, phone calls, and in-person interactions presented in this documentary were lawfully obtained pursuant to 720 ILCS 5:14-3, a statutory exception under Illinois law that permits recording a conversation without the other party's consent when the person recording has a reasonable suspicion that a crime is being, has been, or is about to be committed against them or a member of their household.
The recordings used herein were made for the sole purpose of documenting what I reasonably believe to be criminal acts of coercion, retaliation, official misconduct, and obstruction of justice by government officials acting under color of law.
This is not only a protected activity under Illinois law, it is a necessary act of self-preservation in the face of unchecked authority.
After serving more than a decade for this fraudulent conviction and about 90% of supervised release, this happened.
Lost in limbo. For nearly 2 years, John Spencer's probation officer went silent. No replies to housing, employment, or travel requests. Spencer kept reporting and paying restitution. No guidance, no feedback.
Silence in the face of full disclosure. During the long void of supervision, Spencer sent letters, emails, and made calls, seeking permission to move, work, and disclose his use of legal hemp-derived THC. He cited the 2018 Farm Bill and AK Futures LLC versus Boyd Street Distro, LLC, which confirmed that hemp-derived cannabinoids are not controlled substances if compliant with federal law. I disclosed everything, including the law. No one responded. Hemp-derived Delta-8 THC products that comply with the 2018 Farm Bill's definition of hemp are not controlled substances under federal law, even if psychoactive. No officer, no guidance.
Wait until you hear your live hearing. You'll never believe it. March 18, 2025. Even the courts involved.
Even the courts involved.
After Spencer's motion, the court abruptly struck the requirement for a government response, refusing to rule on key filings and due process claims. A hearing followed.
Good morning, it's Mark Peckold.
Good morning. The United States District Court for the Northern District of Illinois is now in session. The Honorable Martha M. Peckold, 20 CR 697, United States versus Spencer. If you can state your names for the record, we'll start with Government Counsel first.
Good morning, Your Honor.
United States.
Sorry, we couldn't hear you.
Good morning, Your Honor. Ashika Desai on behalf of the United States.
And I'm John Spencer on behalf of myself.
Good morning.
Good morning.
And
Good morning, Judge. Hi, Judge. This is Leslie Cole on behalf of Probation.
good morning. Is there anyone else who would like to honor an appearance? Sounds like we have everybody. Okay, so we're here, or I initially set the hearing to address Mr. Spencer's pro se motion for early termination of supervised release, which is docket 3. Since then, there have been additional filings by Mr. Spencer at dockets 6 and then dockets 8 through 17. Actually, it's dockets 8, 9, 10, 12, 13, 14, 15, 16, and 17. There's also a letter which is at docket 11. Okay, so why don't I, also just reviewing the record, I see that supervised release is scheduled to terminate as of, if I'm understanding correctly, it's scheduled to terminate in May of this year. It was a 5-year term of supervised release, and I believe it's scheduled to end on, at least according to docket number 1, which is the transfer of jurisdiction form, where this case was transferred from the District of Minnesota for supervision. The dates of supervision that are listed on that form are from May 12, 2020 to May 11, 2025. So it appears from that document that the supervision expires by its own terms as of May 11, 2025. Today, of course, is March 18, 2025. So there's been already most of the 5 years of supervision have passed, and we're approaching the scheduled end of supervision in a little less than 2 months. I'm not sure what order would make the most sense to proceed in, but perhaps because, Mr. Spencer, it's your motion for early termination, it makes sense to start with you and then turn to probation of government, or in either order, to add anything they would like. So why don't I first just ask you, Mr. Spencer, to basically summarize the motion and offer any argument you would like.
Sure. As it stands now, I've gotten nothing other than an email from Leslie Coop on March 6th that says they intend to oppose my motion. That's the only thing in writing that I really have that says that. So I made my motion for early termination of supervised release on the fact that it's almost up. I have completed most of it under 100% compliance. And it was only when I asked about early termination on October 7th that the drug test issue even came up. I consistently told them that it was from legal hemp products. I was told things like that didn't matter. So the test came back positive for THC. I was threatened with a violation. I was told to sign some confession forms. I was given 90 minutes basically to sign these things. If you look at the confession forms themselves, it's clear on them that I denied the violation. I continued to ask for the logic, the rationale for this THC ban. Never got any. Not until the March 6th email. I still don't have anything that says that I violated my conditions. I've let them know at every opportunity from October 6th on, and we're all the way in March now. So why, I'm here having supposedly to defend against a violation that's, never been formally, alleged against me. I haven't been able to see any of the toxicology reports. And, I'm asking the court to release me from my supervised release as soon as today. If they wish to contest it, then I wish to, if they try to say that I did a violation or something, then obviously then I have to contest that. I think that that's factually erroneous. I think that there's nothing in my conditions that create this THC ban. So, if I have to get into that, I will. I don't think the burden of proof is on me at this point. It's on them. I would just ask that they don't oppose my motion and you release me from my term of supervised release for good behavior. The fact that I don't see what the point of keeping me on for another 54 or 55 days, what is that realistically going to do except hold me back and create more problems? I don't see the benefit to anybody in doing that. And so, unless they, I guess, tell you that they're going to oppose it and that I did in fact violate a specific condition, I don't know that we need to get into that. But, the burden of proof, I would say, would be on them at that point to prove that. I don't know how they could possibly do that, but, that ball would be in their court, I suppose. Can I leave it there and you can come back to me based on if you have any questions? I don't know what else to say at this point other than that.
Yes, that's fine. I don't see any violation reports. Typically, if probation were going to report a violation, there would be a violation report that was filed on the docket, and there hasn't been one filed. So I don't know. I mean, I'll give the government and probation in either order an opportunity to respond, but or make any comments that they wish, but which they're but there is no, just to be clear, there's no reported violation that's on the docket.
Okay, noted. Thank you for clearing that up.
Okay.
Leslie, would you like to chime in?
Yes. This is Leslie with probation, Judge. So you're right.
Yes,
you're correct, Judge. Yes, you're correct. There was never a violation filed against Mr. Spencer. Mr. Spencer understood that we would not be filing such violation whenever he called on October 7th following our meeting to admit to illicit drug use, taking gummies with THC. I thanked him for his admission. We discussed how that goes against his terms and conditions and how he would cease the use of such. I let him know that we would not be filing a formal violation. However, this goes against his terms and conditions. We would not be setting him up in random drug testing. However, he was still subject to drug testing moving forward. He thanked me. He understood everything. At least I believe he did. And then when he came in February, he inquired again about early termination. I let him know that we could not support probation, could not support early termination at that time because he had the positive UA for cannabis within a 5-month period of asking for early termination. I did let him know, however, he could still proceed with asking the court for early termination, regardless of probation's position. So that's where we're at. He did ask in February for a copy of UA results. I let him know that belongs to the court. He would have to ask the court to release such records to him.
And Your Honor, if I may, this is Ashika Desai for the government. The government is given probation's position and their continued supervision of Mr. Spencer. We have been, Ms. Culp and I have been in contact, and the government's position is the same as probation at this point. Mr. Spencer has tested positive for illegal drug use and THC, which means he's not in compliance with his current conditions of supervision. While the government understands that he has demonstrated compliance with his conditions of supervised release throughout the majority of his term thus far, the fact is that he was not currently compliant when he was tested back in October. And so the government does not support the early termination based on that basis alone, and in conjunction with probation's recommendation here as well.
Okay. Any further comments from Mr. Spencer?
Sure. I don't know if this would be the appropriate, forum for me to cross-examine, my accusers, but I would say that my supervised release conditions by law have to be construed narrowly. That's my understanding. And you can't just graft in anything that you want. And they gave me a reason in the email, and they pointed to some specific provisions. None of them create a THC ban any more than they create an alcohol ban. It says that the defendant shall refrain from unlawful use of a controlled substance. The defendant shall submit 1 drug test within 15 days of release and at least 2 periodic drug tests thereafter as determined by the court. They never got court permission for any of their drug tests. And they claim that there's a condition, special condition B maybe, where they talk about substance abuse and treatment and things like that. All of those things were handled in Minneapolis. It was determined that I didn't need substance abuse. I was on color code. I had more than 3 drug tests that I passed. This drug test never came up until after I asked about supervised release again, and this is after probation ignored me for almost 2 years. So again, I would say, despite what the government just said, and the fact that I feel strongly that if we have to do a hearing, I can easily prove what was said, exactly what was said, and there's no condition that prohibits this. They chose not to investigate. They told me to get rid of the THC, the legal THC. And now here they are maintaining that I violated, but they're not willing to officially file a violation. So, Judge, I want you to notice that and grant my motion for early termination because I think it's equitable. It's really equitable based on the facts. But I guess if, we have to go ahead and do this, then at some point I'm going to need to put my accusers on the stand and, really factually develop this. But I think that's pretty silly for 50 some odd months left, or for 54 odd days left of supervised release. I don't think that it's a factual dispute either. I think it's a legal one. The conditions of release don't say that. They didn't ask the court for any of their drug tests after the third one, and it's debatable whether they had to get court permission for the first couple just by the reading of the actual document, which I'm willing to argue, and I have argued in my pleadings. But for those reasons, and they're saying that they did not file a violation, this is just their position, I would say that, by a preponderance, that it would favor letting me go for the reasons that I said and just what you heard from them today.
Okay, I just want to clarify, there's not going to be an opportunity to cross-examine. That's not a typical...
Well, if you're accusing me of violating and having a controlled substance, I just thought that would entitle me to cross-examine my accuser, just under the Constitution. But if I'm wrong, then, I'm wrong, and I'll have to figure out how to do it, in a permissible way. But, I feel pretty strongly about the facts that I'm declaring under penalty of perjury here in my pleadings.
Okay. So, if, for example, there was a revocation of supervised release, then you would have an opportunity to present evidence. We would hold a hearing. You'd have an opportunity to appear and present evidence. You would have, upon request, an opportunity to question any adverse witness, unless the judge determines that the interest of justice does not require the witness to appear. That's all under Federal Rule of Criminal Procedure 32.1. The 2 capital C. So it's an opportunity to appear, present evidence, and question any adverse witness unless the court determines that the interest of justice does not require the witness to appear. And, similarly, if probation were requesting a modification, then under Rule 32.1 C1, it says, before modifying the conditions of probation or supervised release, the court must hold a hearing at which the person has the right to counsel and an opportunity to make a statement and present any information and mitigation. But again, here there's just not a request to modify the conditions of supervised release, nor is there a request to revoke supervised release. What we have here instead is a motion for early termination of supervised release. And that is governed by 18 U.S.C. 3583 E. So that says modification of conditions or revocation. The court may, after considering the factors set forth in section 3553A1, A2B, A2C, A2D, A4, A5, A6, and A7, 1, terminate a term of supervised release and discharge the defendant released at any time after the expiration of 1 year of supervised release pursuant to the provisions of the Federal Rules of Criminal Procedure relating to the modification of probation, if it is satisfied that such action is warranted by the conduct of the defendant release and the interest of justice. So actually, the provisions of the federal rules relating to the modification of probation do apply.
So are you hearing this? And right now, right, she's talking to her handlers, right? She's covered the microphone. They're trying to figure out how to get rid of me. And first she tried to say that the rules don't apply here for you because this is just an early termination motion. Like, that doesn't modify anything. So she's trying to semantically dispel me because she's used to just dealing with idiots, I guess. But here, it's like, oh, actually, Judge, everything you're saying is fucking false and wrong. If they're going to accuse me like they just did, we need to have a hearing, because they're also, if you put me back on supervised release, they think that they can continue to enforce this illegal THC ban against me, which is illegal. So we need to talk about this.
Okay, so when we look at the federal rules,
now look at this judge's Wikipedia page, and then think about and cross-reference with what you expect from a judge, from a member of the bar, from a expert legal jurist who does this. This is important, right? And think about what's going on here. Did she have to thumb through it? Do you think she doesn't know this stuff, or is she looking for a way out?
criminal procedure relating to the modification of probation, again, that's federal Rule of Criminal Procedure 32.1C. And I read C1 before, but let me just read that provision C in full, because I think it would be helpful just to have the full context of 32.1C. So Rule 32.1C, again, this is for the Federal Rules of Criminal Procedure, says modification, and then it says 1, in general. Before modifying the conditions of probation or supervised release, the court must hold a hearing at which the person has the right to counsel and an opportunity to make a statement and present any information in mitigation. 2, exceptions. A hearing is not required if A, the person waives the hearing. I understand that's not the case here. Or, continuing with C2, capital B, the relief sought is favorable to the person and does not extend the term of probation or of supervised release. And capital C.
What was that? And? Not or. And?
An attorney for the government has received notice that the relief sought, has had a reasonable opportunity to object, and has not done so. So it's saying a hearing is not required if under C2 capital B, the relief sought is favorable to the person and does not extend the term of probation.
As you listen to this, remember from the docket, this is the same judge who got my motion and then ordered the government to respond, got some more motions and then didn't put them on the docket, and then told the government, you don't need to respond. In fact, let's push the hearing back 10 days and we'll ignore his TROs. Now you hear her actively conspiring with her handlers right in the courtroom, trying to figure out a way to make the law work for her so she can deny me a hearing. Is that what you hear?
Or of supervised release. And C, an attorney for the government has received notice that the relief sought has had a reasonable opportunity to object and has not done so. And here, the relief sought is favorable to the person and it does not extend the term of supervised release. It's seeking an early termination. So it is seeking relief that's favorable to Mr. Spencer, and it would not extend the term of supervised release, rather would shorten that term. And under 2C, small c to capital C, that portion's not satisfied because an attorney for the government has received notice that the relief sought has had a reasonable opportunity to object and has not done so, is what the rule requires, and that is not satisfied here. That's C2 capital C. So
But the government is objecting, right? And they just objected on the record. But you're going to say now that that provision isn't satisfied.
I just don't see that a hearing is required under this rule. But nonetheless, I am holding a hearing now.
Right.
And that E1, ultimately 18 USC 3583 E1 allows me to terminate a term of supervised release early after the expiration of 1 year of supervised release, which is the case here, if it is satisfied, if the court is satisfied that such action is warranted by the conduct of the defendant released and the interest of justice. And I do not find that to be the case here, given that...
Now, when you go to federal court, you cannot expect things to be fair. You can't expect things to go your way. Now, even when they're cheating you, you have to remember, stay composed. You have to continue to develop the record. These are the same people who, after a rigged trial, while I'm on appeal, threw me in the hole, stole all my legal evidence, got rid of it, and then transferred me to a higher security prison. These are the same people who promised my co-defendant, Patrick Doles, that he'd get immunity, and then when he went to sentencing, they didn't give him immunity. These are the same people now. And you see, this is the same case, right? And here we are all the way at the end. I have 54 days left of this case, and they've ignored me for 2 years, wouldn't approve travel so I could work, wouldn't approve jobs for me, wouldn't communicate about anything important until I asked for early termination. Then they started this pretextual THC ban, which they want to continue. So not only is she saying, I don't need a hearing, there's no objection, and the hearing's over, I'm not going to grant you your supervised release, she's going to ignore all the other things that I raised. She's going to try to. And then the things that she failed to even put on the docket strategically. And now she's going to say that the interests of justice, despite the fact that they haven't supervised me in 2 years, I need to stay on supervision for 54 more days. This is what she's going to say. Expose these people for who they really are.
Given the positive test, relatively recent positive test in October.
And so you hear her saying it too, right? It's the positive test, right? The one that there's no evidence for, no toxicology reports on, I can't challenge it, there's no cross-examination, no real hearing, that one.
Early termination is something that sometimes people will seek if they've been fully compliant with all the conditions of supervised release. If someone's not been compliant with all the conditions, it doesn't necessarily result always in a formal violation report being filed, but I would not find that early termination is warranted when there's been some violation.
Oh, so it is a violation, just not a violation in any kind of challengeable way.
In the form of a positive drug test.
Oh yeah, that, right? That toxicology report that has never ever been produced. I mean, we don't even know if I really did test positive, right? You won't even show me the toxicology report, and this is clearly what you're using to make your decision, no matter what you say later.
And it's not in the interest of justice to early terminate in light of that.
Can I speak, or is that final? I don't want to interrupt you, but
No, please go ahead.
Okay, so just to counter that, I would ask you to reconsider because, again, I've been stating that I did not violate my supervised release conditions. In addition to that, I let probation know that I was using legal cannabis products. When I attempted to talk to my probation officer about it, she told me that that doesn't matter. A failed test or a positive THC test is a positive THC test. And that's simply not true. On top of that, well, I guess nothing on top of that. That I didn't violate my terms of supervised release. Notwithstanding this THC positive test, I was never given a meaningful opportunity to challenge that test, other than my statement that was clearly accepted on its face that I used legal THC products. I was instructed to get rid of them, which means now I don't even have the legal THC products to present for an investigation. And there's only prima facie evidence that I failed or that I violated my supervised release conditions. So the government has not satisfied their burden of proof, and they can't do that. So now they're saying that this test is enough, and what I'm hearing is that you're concluding that in the interests of justice, it's not. But I participated in 100% legal behavior, legal conduct. I was upfront about it. I let my previous probation officer know about it. She didn't respond to me for almost 2 years. And now when I asked for early termination of supervised release, the test, which did not have, this is the fourth or fifth test that I've taken. And I feel like the court is just kind of overlooking all of those things. And I would ask the court to reconsider based on that.
Okay, so when you say you were using legal cannabis products,
Yes, ma'am.
I don't know that so even though cannabis is legal in at least some instances, in many instances under Illinois law, under state law, cannabis remains illegal under federal law.
So I like to go to the record, right? Court, United States District Court of Northern District of Illinois, criminal docket 120 CR 00697-1. When my case was transferred to Illinois from Minnesota, that's docket like 1 and 2 right in here. And we get down in here to submission of pro se motion by John Anthony Spencer for early termination of supervised release. That's on 2/28/2025. That's document 3. The other 2 documents are just when it was transferred from that same criminal case. And I just want to show you what's going on in the docket. So they get my submission. Then there's an appearance by the government right here at number 4. And so then there's a ruling, and the judge says that the government is directed to confer with the probation office and file a response to defendant's motion, number 3, pro se motion for termination of supervised release by 3/11/2025. And that was entered on 3/4. So then they get my discovery motion. That's document 6. I'm going to show you that document. Okay, so this was document number 6, defendant's motion for discovery and to compel production of documents necessary for the adjudication of defendant's motion for early termination of supervised release. I'm saying that these things are going to have impact on the hearing. The hearing that you're hearing right now, these are all the things that I'm asking for. But before we really get into this document, let me show you the actual motion for early termination. Let me show you what that motion looks like. Okay, so remember, this is in Illinois district. That last document you saw, the discovery document, that was number 6, that was filed on March 4th, 2025. And my initial motion, document number 3, which I'm going to show you now, was filed on February 28th. And that's the document I'm going to show you now. So the document I'm going to show you now was filed first on February 28th, and then on March 4th, they got my discovery motion. And then on 3/10, we have a new order. Let's look at what my actual motion said first. Okay, so this is document 3, filed February 28th, case 120 CR 00697, related to the same criminal case that we've been talking about. Simply jurisdiction was transferred to Illinois. There's 56 pages in this document, so there's a lot of argument developed here. But I want to go down to page 7, just show you a couple things that I'm specifically talking about. The 2018 Farm Bill, levels below, Point 3, controlled substances, how this act affected the legality of Farm Bill hemp versus controlled substances. I talk about how I had informed probation that I was using legal THC. And I talk a lot about the reasons for needing to get off supervised release. And then I provide a bunch of evidence, a bunch of affidavits, a bunch of evidence of what I'm saying, right? They know exactly what I'm saying, how they ignored all my issues on appeal. Then in my 2255, they told me I didn't raise those issues. I told them about how my co-defendant, Patrick Doles, for his immunity, right? Recanted, right? And just provided them, with, so they know everything. Here's the false confessions, right, that I write on there. I acknowledge the positive test for THC cannabinoids, which I shouldn't have done, but I was believing that they must have at least had that. I don't even know if they had that now, but based on my understanding, my release conditions in federal law, THC containing products consumed or not, by definition, a controlled substance. So, all that was in the record prior to this hearing. So now we're back in the docket, and this is the important thing here. They got that discovery motion, right? And about that time, the court said, let me stop the government. The 3/11/2025 deadline for the government's response to defendant's motion is stricken. A hearing is now scheduled for 3/18, right? And you remember that the original hearing, 3/13. So they pushed the hearing back 5 days, even though I have TRO motions before the court that I'm going to show you in a little bit. I then mailed a bunch more motions, including, talking about how the government is trying to graft in a false, unlawful THC ban. And I break these arguments down. I ask for a temporary restraining order because they're saying that I can't exercise my legal right to consume legal hemp. And they're saying if I do or I possess it, that's going to be a violation. I risk even incarceration for that. I need a TRO order. So she ignores that, doesn't put it on the record, the judge now, the court, because they were signed for. I'm going to prove to you that they were delivered to the court, and the court just left multiple documents off the record prior to the hearing that we're in now. But one of the most egregious overt acts by the court beyond that is pushing the hearing back, ignoring the TROs, and then striking the government's response because she wants to save the government from having to lie, state a position, expose their bullshit. Because right now what they're doing is they're punishing defendants with no due process. They're saying, oh, you got a THC positive test, that's a violation, when that's not true. There are legal sources of THC, and the government doesn't want to do investigations. They know they can't prove this. They don't want defendants saying, oh, it was legal THC, and them having to prove it because it'd be very hard for them to prove it, right? And the burden would be on them. So they want to alleviate the government's burden and try to shift a burden on me, and they're trying to do it real craftily while giving lip service to actual laws. Do you see that?
And I think it's a common source of confusion for people who are under supervised release.
Wait, Judge, did you say it's confusing for the people on supervised release or for the people who are supposed to be supervising the people on supervised release? Who?
That even though cannabis is legal under certain states' laws, including Illinois, it remains illegal under federal law. And so I don't know whether, I mean, do you have any argument that
Again, is this person really that incompetent? I mean, if we look at their Wikipedia page, all this education, you're a federal judge, you don't understand the criminal code, it's ridiculous. This is preposterous. What do you think? This United States judge is purposely trying to stop the record from being developed. She's ignoring evidence, signed affidavit, third-party signed affidavits, evidence, documented electronic evidence, emails, letters sent back and forth, postal receipts. She doesn't care about any of that. And she says that she doesn't know anything about legal marijuana, legal hemp. They keep misnaming it on purpose. Playing dumb. They don't know anything about this. This is a United States judge who sentences people under the criminal code. Do you want your kid, your son, going in front of this judge who is purporting to not even understanding the criminal code or the hemp bill or anything like that, and is purposely trying to find ways to stop a defendant from advancing his case and creating facts and developing a record? Is that what you want?
Argument that it's legal under
I do.
it simply is not.
Oh, okay. So the 2018 Farm Bill legalized THC products, certain THC products. Those THC products have to have a THC threshold under the controlled substance limit, but they can still cause positive drug tests. I told probation that I was using legal THC under the hemp farm bill, specifically talked about the legality that this was made legal by Congress, an act of Congress. My conditions specifically say controlled substances. The hemp Act of 2018 made those substances no longer controlled substances. The probation told me to get rid of them, didn't investigate, and they only have a THC positive test. They ignored what I told them, didn't want to look at my evidence, gave me no meaningful chance to oppose it. Now they don't want to file a formal violation where I can have a meaningful chance to oppose it, and we're saying that I violated my supervised release conditions. There's not enough evidence for that. Probation could have said, well, what did you take? Let me see. They could have said, I could have admitted, oh, I took cannabis, but I didn't. I told them specifically what was going on. I told them this before Leslie Culp was my PO, and there was never any issue about this until I asked for early termination of supervised release. And that's my argument, that the Congress, by an act of Congress, this is not a controlled substance. And there's only prima facie evidence at best, but there's no preponderance of the evidence that I failed my test, given what I told probation, given that they didn't want to investigate it. This is just, like taking a test and saying my conditions do not ban THC and they don't ban alcohol. So if you're going to construe my conditions liberally or narrowly in my favor and not expand them to say something that they don't, and then I say, look, this is legal THC, I could fail this test. I told them this again on October 7th, even before the test came back, and then they don't investigate it, but yet try to get me to say that I used a controlled substance and I maintain that I haven't. I'm going to potentially be punished for legal conduct with no investigation at all, for conditions that don't say that, and then for an act of Congress which legalized the products that I had. I think you should reconsider based on that. I think that that's a strong argument.
Okay, so I mean, I don't at this point. So first of all, let me just say, you've mentioned at different times that the government has the burden of proof. It is actually the defendant's burden when it comes to early termination of supervised release. So the case United States versus George, 534 F 3rd 926 927 Northern District of Illinois 2021.
So I have the burden now to disprove this non-existent violation. Wouldn't that be a good reason then to grant me discovery and help me get my evidence into the record, call some witnesses, cross-examine some other witnesses? Wouldn't that be what I need to do then if I have a burden, and if you won't let me do it, aren't you stopping me and preventing me from satisfying my burden?
That says early termination of supervised release is not an entitlement. Instead, quote, the defendant bears the burden of demonstrating that early termination is warranted, end quote. Again, that's from George 534 F sub 3rd at 927. So the burden is on the defendant to demonstrate that early termination is warranted.
Okay.
And I would need, I would need confirmation of what products he took. I would need also more information about how those products actually, or were they actually legal under federal law? You've described in the hearing today.
Think about that for a minute. Isn't that really the job of probation? If they're going to say that I violated and I've tested positive, that's their job to now prove. It's not for me to hand over, anything. I don't need to incriminate myself. I don't need to do anything until I, show up at the hearing. Leslie Culp said that I cannot consume nor possess. And she said I need to get rid of any THC gummies, any THC product whatsoever. Didn't want to do an investigation. And now, because you didn't do that investigation, you told me to get rid of the very evidence, the exculpatory evidence that would clear my name. Oh yeah, these are legal. Right? Now, you don't want to formally file the violation because you think this is some trick where you can put the burden on me. Now you're saying I have to prove that I took legal gummies rather than you prove that I possessed a controlled substance. Do you see how inherently corrupt this is?
The Farm Bill, but it's, I don't have in front of me actual briefing on that issue.
Did she just say she didn't have the argument before her? So let's go back to the docket. Remember when I filed all that stuff and I said some things were not filed? And she changed her ruling on the 10th to prevent the government from writing anything down, making, any statements. She saved them from that. And then she pushed the hearing back. Remember when she did that? So she did that. Let me show you when she did that. She did that on 3/10. Let me show you when this was added to the docket. What time of day? Because that's important that this ruling came out. Let me show you. This ruling came out on 3/10. So here's the actual email that I got from the court, right? And I got that March 10th, 2025 at 4:23 p.m. 4:23 p.m., right? And this is the one where they're changing the hearing. The deadline for the government's response to defendant's motion is stricken. This is that one. And you see I'm getting it on March 10th at 4:23. So this is my actual in-sent email, right? And I'm sending it to a third party to print these documents out and send them to these people. And you see Tuesday, March 4th, 8:43 a.m. Let's go to the first one. Notice to the court regarding probation misconduct and due process violations. Second one, defendant's motion to challenge presumptive drug test result as insufficient evidence of violation and to assert due process violation and supervision enforcement. Defendant's motion to challenge unauthorized modification of supervised release conditions. And the last one for today, there are other documents not filed as well. What is this? This is the affidavit. So all of those were sent March 4th, 2025, 8:43 to the person, and I watched them print it out and then mail it. I saw the process myself as well, but you want to include a witness in the loop just for situations like this, right? So there's no getting out of it when they lie. This is my inbox later that day, March 4th, 2025, 10:21 a.m. This is the receipt, right? And I want you to pay attention to the number on this receipt. Here it is, tracking number, ER 132357661 US. So let's just compare it to this, right? And this was in the possession, March 4th at 9:57 a.m. This is the chain of custody. And look here, your item was delivered to the front desk reception area or mail room at 2:27 p.m. 2:27 p.m. on March 5th, 2025 in Chicago by A. Bias, right? It would be the perfect name for somebody at this court to be Bias, right? But this was clearly sent through the mail, signed for, and then not put on the docket. And then there was the court saying that I didn't develop my arguments good enough. I think that also constitutes in this case as mail fraud, doesn't it? Okay, just to give you a visual perspective of what we're looking for, if we were looking at the docket, right, we would find all of these right here with the X's on them. Those would be in the docket. Motion to challenge drug tests, motion to challenge supervision modification and retaliation, notice of probation misconduct and due process, and then an affidavit by me swearing under penalty of perjury to the facts in those documents. Right next to it, you have the tracking number, and over here you have the date, and none of those documents, as you're going to see, were ever put on the document, and then you hear what you're hearing in the hearing now. So now when we go to the actual docket, what was actually docketed, we're going to go down to between, 3-4 and 3-5, and we can see that none of those things are on the docket. And I assure you, as you go down, you'll see some of my other motions, and I've got receipts for all of them.
but you don't get down to our hearing until 3/18. You won't see those documents, although they're signed for by 2:27 p.m. on the 5th, more than 5 days before the document number 7 order by the court to
strike the deadline for the government's response, right? Because we don't want the government having to, what can they say? Anything they say would, probably make things worse. So let's just stop all that. Let's push the hearing back. Let's give us some more time to dissect this.
right. And then in the process, my stuff never gets on the docket. I would tell you right there, that's fraud on the court.
And so I'm just not in a position to make a finding today.
Okay, so if the burden is on me, can I ask a question real quick just to kind of clarify? You said that you don't have the farm bill in front of you. I get that. I did touch on that in my pleadings. I did list the farm bill. And you said also that you would want to see, what products did I have. What has to be understood here is that I was instructed to get rid of all of my products, and probation didn't even want to entertain what I was trying to tell them. So now you're saying that the burden of proof is on me, but I guess can't we delineate between like where that burden goes to and where it ends? Because they didn't give me a violation, and I'm saying the interests of justice weigh in my favor for all the time that I've been on it. I've complied. I've made my restitution payments. I understood my supervised release conditions. I read them. I had to sign them. I was told these are what govern you from the very beginning. And then when I go to enact those or to rely on those and rely on the explanations that I've been given in the past, and then also the silence is consent principle where they didn't say anything to me about any problem with legal THC until I asked for early termination, and now they're telling you that I tested positive. I hear you, but I don't think that I should have to now prove, or you should at least acknowledge the prejudice to me proving what products I would have taken back in October when we're in March and they told me to get rid of them and didn't even want to entertain that. Like, that's valid. You should have seen the products. That should have been documented. And I tried to present that evidence then, and I was told under threat of more violations to get rid of it.
Right here, I was just hoping Culp would speak up and perjure herself. She would lie. She would give some false testimony, because that shows that she's got a guilty mind and she's trying to cover up her wrongdoing. Now, she told me to get rid of the evidence, not use it, but I knew in my heart of hearts she was going to lie about something. I was just hoping she would, because I assure you that I can prove unequivocally, verbatim, every single thing that Miss Culp said to me in every single conversation that we had.
So do you see how that prejudices me trying to prove this now?
I just am not in a position to make a finding on that either.
Okay. So it sounds like to me maybe there'd be maybe an opportunity for more briefing or more arguments on that.
I'm sorry, did someone else want to jump in?
Yes, Judge, this is Leslie with probation. Thank you. I just want to put on the record, Mr. Spencer was never told dispose of those products, get rid of those products.
What a willful lie. Is that reason number 99 to do your jury duty, but nullify all federal trials? Because you know that all cops lie, all POs lie. They just go in, they lie. Think about how absurd this lie is. And then think about how absurd it would be to claim that the weight of the evidence on testimony like this somehow defeats my cause. But on March 6th, she says, I've attached the email response in PDF form, right? She's talking about this email. She says that I've attached another copy of your terms and conditions, which you acknowledge you signed. You'll see the following. The defendant shall not unlawfully possess a controlled substance. That's what it says first and foremost. You're going to tell me that you had a problem with me consuming it, but I could go ahead and then just continue to possess it. That was cool. That's what she just told the court. And it's a clear lie. Guess what? It's not even an argument, right? I can prove beyond a doubt that she said that, reiterated, and said it multiple times. I can prove that. So here's the lie. I'm thankful for it. And now I want to get her up on the stand, or I want to cross-examine her. I want to impeach her. Most of the evidence I have is probably impeachment evidence, right? Since I can testify to it to myself. This is what happened. They can then deny it, and then I can impeach them one by one with this evidence, because they're all fucking liars. Nowhere do you hear anything about Culp saying, I asked him to see it. I confiscated those. I looked at him. I did an investigation. I gave him an opportunity. You don't hear any of that. Keep that in mind.
It was just said, cease using those products. You need to stop using them. You cannot use those products moving forward. And he understood that. That's all.
And okay, Judge, I will tell you that that's completely untrue. I would be more than happy to impeach that witness at the appropriate time. But I was instructed to get rid of them, and that's what I did, under threat of being caught with them being violated for having these legal products. So, that's how I would respond to that. And it definitely prejudiced me now. The other thing is that's why the 35 or maybe 3603, all of my discovery stuff, it should be written down in these records what I told her on October 7th. And when you look at all the written records, I promise you that it weighs in my favor what I'm saying. Exactly what happened is what happened.
Let me just return to the basic point, which is that early termination of supervised release is not an entitlement. So the sentence that was imposed, I was not the sentencing judge. The sentencing judge was in the District of Minnesota. But the sentence that was imposed included a 5-year term of supervised release after a total of 125 months of imprisonment, which was different sentences running concurrently, but ultimately it was 125 months of imprisonment followed by 5 years of supervised release. And that's the sentence that is in place. Again, early termination of supervised release, there's no right to it. And so when you keep saying there's prejudice to you, that's not...
Here's the judge saying, no matter what you say, I'm not going to let you win, because I know how to inoculate my ruling by giving lip service to some statutory factors and some language. And it's going to mean that I did this with my discretion, right? And you didn't deserve it. Even though the government ignored you for 2 years and all this other stuff, be what it may. We're not going to develop it. We're not going to get to the bottom of it because you're not getting any relief. And I'm going to now tell you with a straight face that you need to be supervised for 54 days. And I'm going to come up with a list of reasons to justify it.
Oh, okay.
I understand your argument is that you wanted to file for, or you did file for early termination, and you are arguing that you lacked all the evidence. You now lack all the evidence you would have liked to present in support of that petition. But number one, the probation office says that you were never instructed to dispose of products, just to discontinue using them.
Oh, that's what she said, huh? So it's settled then, right? She said that, and no proof in the world can change that, right? So that's number one, huh? I did offer to impeach witnesses, and I said that's clearly false. And I also had at least one third-party affidavit provided to the court, sworn under penalty of perjury, that culprit said these things. So I've offered to prove she's lying. I've submitted evidence that she's now controverting, and the court says, well, even though I'm an unbiased, disinterested, third-party fact finder, and I'm fair and impartial, she said she didn't do it, so that's the end of it. And so the real reason why they keep doing this, and while they're mischaracterizing it or misnaming it, they keep calling it cannabis, and they don't want to, refer too much at all to any of my arguments because they don't want it to be on the record. They want to keep it away from people doing searches even for these words like hemp bill, probation. They don't want other people on probation finding out that they've been doing these treacherous, illegal things with these THC bans where positive tests are not proof of anything. They're merely prima facie evidence. And the burden to prove something like this is on probation. It's on the person accusing, right? But they want to keep all of this out. They don't even want you to be able to search it and find it. So they keep saying things like cannabis and things like that to throw you off the trail.
And number two, regardless of what happened there, it doesn't really matter because
let me guess, you're going to make sure it doesn't matter.
Early termination again is not an entitlement. It is something that the court may do. So going back to the statute, 18 U.S.C. 3583E, it says the court may, after considering various factors set forth in various subsections of Section 3553, A1, A2B, A2C, A2D, A4, A5, A6, and A7, terminate supervised release early, essentially, at any time after the expiration of 1 year of supervised release, if it is satisfied that such action is warranted by the conduct of the defendant released and the interest of justice. And so all of that, what can get lost in that is that it starts off with the word may. The court may terminate supervised release early.
Understood.
So first I have to make the finding that the action is warranted by the conduct of the defendant released and the interest of justice, and then I need to consider all these factors set forth in Section 3553, A1, A2B, A2C, A2D, A4, A5, A6, and A7. And then I may terminate early but it's a discretionary decision, and it's not a right. And so I am not satisfied that that the early termination is warranted by the conduct of the defendant or the interest of justice. And even if I were, I have enough concerns, having now sat through this hearing, that I just don't find that the interest of justice is satisfied.
This judge is trying to put on the record with a straight face that after they sat through the hearing, they have some concerns. You have to continue to develop the record. You have to remain composed.
Can I ask you to kind of articulate why that is? If I didn't, are you saying then that the evidence is that I violated my supervised release? I guess I'd like some clarification on that. That's what you're ruling. Cause I guess I just need some clarity then if I'm going to appeal. And then if you could articulate why you say the interests of justice aren't, because I think short of that, the prosecutor or the government saying that I tested positive for THC, I don't think you would say that.
So I don't find that there's not been a sufficient coherent demonstration of how the products that you claim are legal under federal law are in fact legal under federal law. I understand that perhaps they're legal under Illinois law, but you've not presented a coherent case that they're legal under federal law. You've mentioned the Farm Bill, but it's not clearly teed up. It's just you flagged it in the hearing. You may have flagged it in some of your filings, but you've filed so many filings that it simply doesn't tee up the issue clearly. It just based on, even a quick internet search, it looks like the DEA says that a lot of THC products are still illegal. So I just find that it's not been clearly teed up.
I'm going to say bullshit and shame on you, Judge. It's 2025. The Farm Bill's been out since 2018. You're a federal judge. You're in here trying to convolute and confuse the record. And you know damn well what the Farm Bill is. And you know that the first time I disclosed to a PO, I raised the Farm Bill. That's what everything says, right? All my statements of facts, no matter how many documents that I filed, they all have the same statement of facts that I disclosed this based on the Farm Bill all the way back in at least 2003. Now we jump ahead to 2004 and I ask for early termination of supervised release. And in my 3583 motion, I bring up the Farm Bill again. And I say that one of the reasons in equity you should let me off is because this unlawful harassment by cult for this fabricated unlawful THC ban. And again, I talked about the Farm Bill. So whether you filed it or you tried to keep it from the record and hide it, it's well established in my pleadings. Now, if you think I pleaded too many pleadings, well, that's just too bad, isn't it? That doesn't give you an excuse to not read them and decide the case against me.
Well, I have
your point.
I did.
Please don't interrupt the judge, sir. Please don't interrupt. And so I am not convinced that these products are actually legal, and you also haven't identified what the products are.
So where would I have done that at? What was the best time, in the judge's opinion, to disclose these products, which I did disclose, but she says I didn't. So would it have been in this hearing? When exactly? Would it have been in one of those numerous pleadings that you're complaining about? There was so many. Oh, I got it. In one of those pleadings that your clerk signed for that you purposely left out of the docket. And as the hearing develops, I think it's going to be pretty clear. You don't know what the fuck you're talking about.
It's clear that you did test positive for THC.
It's clear? Wow, this must be ex parte communication. That's what this is, right? You're saying it's clear? So you're referring to this mysterious toxicology report that I've never seen, that I've asked for at least on all of those dates, right? I've made motions to get it. I filed FOIAs to get this toxicology report that you claim I tested pot, but it's clear, you say. Do you see now why police officers, government officials have no fear of treating you so badly, disrespecting you, violating your rights, depriving you of rights? They have no fear, none at all, that anyone in the court system is going to hold them responsible.
At least, in October. We're now in March. That's reason enough that I do not find that the interests of justice are served by an early termination.
Okay, I don't want to interrupt, so I'm not saying anything. May I speak?
1 second, please.
Oh, okay.
Okay. I'm also required under 3583E to consider the factors set forth in Section 3553A1, A2B, A2C, A2D, A4, A5, A6, and A7.
Judge, I hate to bring this up, especially now after you just read that, but isn't it a little late to do all that now, especially considering that you've already declared your ruling?
And just to go through those factors, that would be 3553A1 is the nature and circumstances of the offense and the history and characteristics of the defendant. A2B is the need for the sentence imposed to afford adequate deterrence to criminal conduct. A2C is the need for the sentence imposed to protect the public from further crimes of the defendant. A2D is the need for the sentence imposed to provide the defendant with needed educational or vocational training, medical care, or other correctional treatment in the most effective manner. A4 is the sentencing guidelines, essentially the kinds of sentence and the sentencing range established for the applicable category of offense committed by the applicable category of defendant as set forth in the guidelines. And then 4B is in the case of a violation of probation or supervised release, the applicable guidelines or policy statements issued by the Sentencing Commission. As already discussed, there's not an actual violation that's been reported. A5 is any pertinent policy statement issued by the Sentencing Commission.
So do you see what she's doing? She had a pretextual agenda, right? She made a decision without even thinking about the law or the facts, right? She just made a decision that she wanted to make, that she needed to make for the home team. Now, post hoc, she's trying to rationalize it and legitimize it by marrying it to some statutory language. And right now she's looking through to find the best language for her use.
A6 is the need to avoid unwarranted sentence disparities among defendants with similar records who have been found guilty of similar conduct. And A7 is the need to provide restitution to any victims of the offense. So I would find that even if everything you've said is true, that you did not actually violate the conditions of release, I would find that considering all the circumstances and all those factors that I just walked through from 3553, which are enumerated in 3583E, and in particular, the nature and circumstance of the offense and the history and characteristics of the defendant, and the need for the sentence imposed to afford adequate deterrence to criminal conduct, I would not find that an early termination is appropriate here. It was a serious offense.
I would say that acting under color of law, trying to enforce a false and fraudulent, unlawful THC ban, then using intimidation and coercion to try to enforce and institute this ban only as retaliation for me asking for early termination is also pretty serious, right? And now you're saying that for the public safety, I need to be monitored on supervised release, even though it's virtually uncontested that they've ignored me for 2 years, but we need to do another 2 months of official ignoring, neglecting, incompetent supervision. We need another 2 months of that. Won't give me permission to travel so I can get my evidence, which I've said is in another state. I need this evidence to clear my name. Again, no response, no permissions given. But we need to continue this for another 54 days, even though they're not doing their job, which I demonstrated to you in all those calls I made on March 6th, right? Chief Probation Officer Holmes, right? I called him. I called the on-duty officer, right? This is what you got to do to get them to do their job. But I need to be on supervision for another 54 days, according to Packold here, to this judge.
Although I was not the sentencing judge and the sentence occurred in the District of Minnesota, just reviewing the materials or the docket that is on in this docket, those refiled in this docket. It's at docket 2 of our docket. As I mentioned before, there was a very substantial sentence, a term of 125 months, consisting of certain concurrent terms, followed by 5 years of supervised release. The underlying offenses were conspiracy to commit mortgage fraud through interstate wire and to commit bank fraud, mortgage fraud through interstate wire, bank fraud, and engaging monetary transaction in criminally derived property. the length of the sentence reflects the seriousness of the offense, and I do not. Again, early termination is there's no entitlement to it. The existing sentence includes a 5-year term of supervised release, and and I just would not find that in light of the in light of the underlying I would say, in light of, so just to be clear, it's 3553A2A is not among the factors that's listed in 3583E. So it needs to be confined to 3553A1, which is the nature and circumstances of the offense and the history and characteristics of the defendant. And the other enumerated factors in 3583.
Yeah, those other ones. Don't even worry about it.
That would be 3553A1, which I just mentioned, as well as, among others, A2B, to afford adequate deterrence to criminal conduct. And so I would find, so let me just clarify, I'm not considering 3553A2A, which that's the seriousness of the offense, to promote respect for the law and to provide just punishment for the offense. Rather, I'm considering 3553A1 and 3553A2B, and considering those factors, the nature and circumstance of the offense, the history and characteristics of the defendant, and A2B to afford adequate deterrence to criminal conduct. I don't find that, even if the early termination were warranted by the conduct of Mr. Spencer and the interest of justice, or
oops, you didn't say that.
let me just strike it. Even if I were satisfied that early termination were warranted by the conduct of Mr. Spencer, even if he had complied with every condition of supervised release, the interest of justice would not be satisfied based on 3553A1 and A2 capital B at a minimum, as well as A2C to protect the public from further crimes of the defendant. There is some, there is a need for that, and supervised release serves a purpose in that regard. A2, and I understand that there's only 2 months left, less than 2 months left on supervised release, but there is some incremental benefit even from that little bit less than 2 months. And so,
okay.
Okay. For all those reasons, it's not in the interest of justice to early terminate.
If I can ask the court something about their ruling.
Sure, and then we're going to conclude the hearing.
Okay, so you mentioned the seriousness of my crime. I would just say that my crime and then the conditions that I'm alleged to have violated
I'm not on a drug crime. Then I guess I would ask what other crimes I don't see the public deterrence factor. The court seems to, I'm wondering, has the court overlooked where I've said specifically, and I'm looking at my affidavits, and you are right that there are a lot of things filed, but I feel like I did develop the THC Farm Bill. I was very specific that I used THC of 0.3% or less, all the products. And you said you would want to see that. Well, I was never given any meaningful opportunity to present that. When I offered to discuss that, I was turned down and told that it wasn't going to happen. So now you're saying that the burden of proof is on me, but I've never really had an opportunity to do that. It's almost like by not filing the violation, the government can get out of having to prove their violation, and then they can do what they wanted to do, which is keep me on supervised release. And then you've recited all of those things, but the nature and seriousness of my crime has to do with money laundering and bank fraud and mortgage fraud. It doesn't have anything to do with drugs or controlled substances. So I feel like, again, like that's kind of just being overlooked. And then I did make a motion for summary judgment based on the fact that my conditions do not create a THC ban. So I guess I would ask that you would rule on those motions too.
Okay, so there doesn't need to be the conduct of unsupervised release doesn't need to be the same conduct that led to the conviction that's underlying the conviction. So the fact that the conviction was for mortgage and bank fraud and those type of offenses and conspiracy related to those, yet now the issues that are coming up, whether they're a formal violation or not, relate to potential drug use. That's not a reason to discount the current issues, because supervised release, there's a variety of conditions that are imposed. And if someone is, for example, using drugs, is slipping back into drug use, it can present a risk of recidivism. It can present a risk of returning to crimes of various kinds, whether it's mortgage or bank fraud or something else entirely. It is very possible that drug use, it's not a given, but it is a possible, it's a possibility, and it is a risk for recidivism. And so that's why the conditions of release, they include conditions that get at drug use and are an attempt to help people avoid it.
Is she or is she not basing her decision on some alleged drug use that's not really in the record, which I'm not allowed to contest, but she knows about it, it's there. There's a toxicology report that says I tested positive for THC, which is not proof that I've done any illegal drug use, I've had any controlled substances. It's only prima facie evidence that I have THC in my system. It could come from legal sources, it could come from a controlled substance. There's no proof that it came from a controlled substance, and all the evidence is that it came from a legal source. Yet she's saying that she worries about recidivism and drug use, my potential drug use, based on this ex parte communication of this toxicology report that I've never been able to see, which isn't really on the record. And this is the major factor, is it not, in what she's deciding here, according to her?
Because the purpose of supervised release is to try to help people reintegrate into the community after time in custody and to avoid further crimes, to avoid recidivism. And so there are a bunch of conditions that get at those purposes.
That's true.
So it doesn't matter that it's not a reason to early terminate that.
I'm not saying that it is either, though.
Potential issue on supervised release has. Okay, please don't interrupt. And the second thing I would say is that the motion for summary judgment and temporary restraining order, and there's also an emergency motion for temporary restraining order and preliminary injunction. Those are civil type of motions that that's not a process that's just not are not motions that are contemplated under the rules of criminal procedure.
So that is a complete lie, or the judge is incompetent. This is black letter law. To the extent that civil rules do not interfere with the criminal rules, civil rules apply. Black letter law. Well, if they're not contemplated under the rules of criminal procedure, then they should be allowed. Because if there's not a rule that negates that, then my understanding is that it does apply in criminal proceedings. If there's no specific rule that says you can't bring those motions could be appropriate. So that's why I brought those motions. So I don't see where I'm prohibited in any rules from bringing those motions, even though it's a criminal proceeding.
Okay. Well, they're just not. There's also not something where I can grant a judgment. So, for example, like motion for summary judgment, there's not. It just doesn't. That's not a recognized next step. Also. Also, let me just add another site by way of illustration of the complexity of the legal issue as to whether hemp or THC as to the status of THC. So, AK Futures LLC versus Boyd Street Distro LLC.
Okay, so let's go to the docket now. Let's look at this. Document number 9, filed on 3/11, a full week before the 3/18 hearing. This is motion for summary judgment. So this is what I'm talking about. This is what I'm asking the court to rule on. They don't want to rule on this because their whole case would unravel. It would prove that Culp was acting unlawfully, right? So they don't want to even get into this. So this is document number 9. You can look it up in the case. It's my motion for summary judgment and temporary restraining order. And, essentially what I'm asking the court to rule on is that the plain language of my supervised release conditions does not prohibit the possession or use of legal hemp-derived THC, right? That's what I'm asking them to rule on. It's pretty easy. It's a legal question. This is not a factual question. It's not legal for some people and illegal for other people, right? And so this was document number 9. And this is document number 10, legal theories and points of law in support of motions for summary judgment and temporary restraining orders. And this too was filed with the court a week before the hearing. So case 120 CR 00697, document 10, filed 3/11/25. So very recently. And I talk about the unlawful possession or use of controlled substance versus the farm bill, right? So I kind of flesh all that out. And we go down here to the relationship between a condition when you're construing and trying to interpret what the conditions prohibit and permit. There's rules to that. So I lay out some legal arguments, even some Seventh Circuit law, and how these things need to kind of be resolved in the defendant's favor to the extent that there's any ambiguity, and just a whole bunch of law and facts about how my rights were violated. So now she's trying to school me on this AK Futures case, right? And this case, remember, there's documents in this case that have been filed, and then there's documents in this case that have been delivered but then purposely not filed for whatever reason. Here we are, and I'm being told I didn't tee up an argument, and I'm having a case quoted back to me. Anyway, this is her idea. This is her case, right? She came up with this idea. Just listen to her. And she thinks right now at the beginning that this case cuts her way, but it doesn't cut her way, and it's pretty simple and clear. And you're going to be able to perceive the exact moment when that hits her.
35 F4 682 699 Circuit 2022 has a discussion of the Farm Act and
I'm glad you brought that up.
THC, except in hemp, is still a Schedule 1 controlled substance under 21 U.S.C. 812 C17.
It is.
Okay.
Oh, shit. Did you hear it? Let me play it one more time.
35 F4 682 699 Circuit 2022 has a discussion of the Farm Act and
I'm glad you brought that up.
THC, except in hemp, is still a Schedule 1 controlled substance under 21 U.S.C. 812 C17.
It is.
Okay.
So did you hear it? Did you see when it set in? Got real quiet, didn't it? Because this right here on the board, this is actually the whole ruling in the case. This is what the case stands for right here. The court concluded that the 2018 Farm Bill legalized hemp-derived products containing less than 0.3% delta-9 THC. Exactly what I've been saying. Exactly what I've been saying. And it's in the pleading. She knows it's there. She's probably looking at my pleading that she didn't put in the docket. And it hits her. And she's reading through it. And then she just stops, right? And watch how she abruptly just wants to stop the proceeding now. This is the kind of adjudication that you're going to get. This is the quality of adjudication I got from trial until now.
Okay, so just to summarize and conclude, the motion for early termination denied. That's docket 3. In addition, there are other motions that are pending, all which I will deny. That's docket 6, 8, 9, 13, 14, and 17. All right, that concludes the hearing. Thank you, everybody.
Thank you, Judge.
Take care.
Thank you, Judge.
Bye.
I couldn't make this shit up, could I? Right? On everything. That's a real live hearing. You heard it. You've seen what's going on. And I'm telling you, that's what has gone on the whole time. There's not a single proceeding that hasn't been laced with this goofy bullshit corruption. That you tell me. Haven't seen that. You tell me what you think. Now, I'm going to show you in the next video exactly how now they deny me an appeal on some, like, it just gets worse. It goes from bad to worse, right? You won't even believe it, right? You won't even believe it, but I mean, you already know I deliver the goods, okay? And this ain't even my best stuff, but you need all this foundational information to just know how corrupt and crooked they are and why you need to always nullify, do your jury work, nullify. Nobody that goes before these judges gets a fair proceeding. And then, like, just evaluate the judge. Compare the judge to me, right? Just, what I'm saying and what they're saying, what they're doing. Just compare that. Compare me to the officers in this case, right? And they're talking about the seriousness of conduct, right? All this goofy bullshit, right? Only to make a mockery of real fact-finding and justice. That's been going on the whole time, right? I've got a conviction around me. I did over 10 years in prison. My life's been ruined for corrupt, goofy bullshit, just like this and worse than this.
Remember, I'm just asking questions here.